who has standing to oppose a trademark application. Imagine you're worried that a new trademark might cause confusion or harm your business. Who can actually step in and say no to that application? Let's find out. In trademark law, standing to oppose a trademark application means having the legal right to challenge its registration. To do this, you need to show two main things. First, you must have a real or genuine interest in the outcome of the opposition. Second, you need a reasonable belief that you will be harmed or damaged if the trademark gets registered. This rule helps keep the process fair by making sure only parties with a real stake can oppose. It stops people from filing frivolous or bad faith challenges just to cause trouble. More specifically, someone has standing if they have a personal interest in the case. For example, if you are a business that sells similar products and fear the new mark might confuse your customers, you have a stake. If you own a trademark that is similar or identical, whether registered or just used in commerce without registration, you also have standing. Trade associations or groups that want to protect their members from false suggestions of connection or deception can oppose as well. If you believe the registration could mislead consumers or harm your reputation, you might have standing. Even if you do not own a trademark, you can still oppose if you can show that the registration could cause you harm. For example, if the new mark is likely to cause confusion or falsely suggest an affiliation with your business, you can challenge it. The law is quite flexible here. You only need to show a plausible injury and a genuine interest. You do not have to own a trademark to oppose. When you file a notice of opposition, you must prove your standing and keep that proof throughout the process. If multiple grounds for opposition are claimed, proving standing on just one is enough. The Trademark Trial and Appeal Board will decide if you have the right to oppose before looking at the actual merits of the case. Practically, this means that businesses, individuals, or organizations who believe their rights or interests could be harmed by a new trademark can step forward. This includes competitors, owners of similar marks, or groups concerned with consumer confusion. In essence, if you think a trademark registration could hurt your business or cause confusion, you likely have the right to oppose. You just need to show that you have a real interest and that you believe you will be harmed if the mark is registered.